In 2019, Patreon removed Owen Benjamin from its platform. In early 2020, 100 of Owen's backers filed arbitration claims against Patreon under their terms of service. Patreon filed a counter lawsuit against 72 of those backers in California state court. Now, they went to court today on July 13th of 2020 to talk about what's going on and doesn't look good for Patreon. Let's talk about what is happening, why it's happening, and what the implications are. This is big. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about potentially devastating news for Patreon in the ongoing dispute between Owen Benjamin's backers and Patreon, the service, okay? So like I said, Patreon banned Owen Benjamin in 2019, and about 100 of his backers have filed arbitration claims so far against Patreon. Now, there was some negotiation that happened beforehand and all of that stuff in an attempt to resolve this. And I would imagine the ultimate goal of this is to get Owen Benjamin back on Patreon so people can just support him and he can make content. But Patreon does not want that to happen. They do not want him on the service. And so they are sticking with their guns, and they ended up countersuing these people in court. Now, a lot of people have criticized this thing as some sort of scam or some sort of nonsense that's being brought by Owen and Patreon, or by Owen and Vox Day. And I would caution that people saying that this is some sort of scam or is illegitimate or whatever might not have any idea what they're talking about. Now, you cannot like Owen Benjamin and Vox Day all day. I don't care. That's up to you. But let me just say that under California law, there are some really big implications here, and it's the nuances of California law specifically that bring such a weird question to what's going on. And you have to remember that not only Patreon, but tons and tons of tech platforms have this mandatory arbitration, and they mandate the arbitration to happen in California, and they've been doing that for a long time. And it was part of a particular strategy against their consumers. They'll never say it, but it was. And part of that strategy was to go to arbitration, but then delay out paying fees and cause all sorts of trouble. And arbitration itself was sort of a bar because it's kind of intimidating for people to go into, and you need to hire a lawyer, and the arbitrators might be friendly to the businesses, whereas in court there's more of a presumption that it's a little more even-handed towards consumers, and there's a whole lot that's gone into this. But now, when a company is being tasked with actually dealing with these arbitrations, they're running for the hills. But why are they running for the hills? I've been talking about this on and off on my live streams, culminating last week in an actual read-through of the factual scenario, the factual background from Mark Randazza's filing in this lawsuit. Mark Randazza is representing the 72 backers that Patreon has sued in California court. Now, to my knowledge, Mark is not involved in the arbitration or anything like that. He is just representing them within this particular action in California state court. But we read through the factual background, and I'm going to pull some sections out of that for this video. So I'm going to ask you to bear with me as we bounce through a lot of things. I'm going to try and keep this as concise as possible, but there's a lot going on. And where we're going to start is reporting live from the courtroom was Mike Cernovich, tweeting out what was going on, and we're going to use that as a basis. So guys, go check out Mike Cernovich's Twitter, and he also has some information up about this on his website, cernovich.com, if you want to get some more info or a different perspective than mine. Mike was actually there, and so we're gonna jump start it with some of his tweets, and then we'll go through the filings, and we're going to take a look at what all of this means and why it is so devastating for Patreon if this goes wrong. All right, here we go. Cernovich. Reporting live from a major legal action involving Patreon, several former patrons of Owen Benjamin. They filed an arbitration against Patreon, and then Patreon then sued them. So he sets up the foundation here. And here's, like I said, a link to cernovich.com where you can check out Mike's information about it. And you should go do that. You should go do that. So under California law, Patreon is obligated to pay in advance all of the arbitration fees required in the case involving Owen Benjamin's former backers. Millions of dollars. Seeking to avoid these fees, Patreon moved for an injunction to shut down the arbitrations. So, real quick summary of this. Every arbitration has a filing fee, and Patreon uses what's called the JAMS streamlined rules for arbitration. JAMS is an arbitrator, and you can go look all of this information up. You can look up the fees and stuff like that. But the long and short is there's an initial filing fee, but under the streamlined rules and the fair dispute resolution policies of JAMS, a consumer bringing an action against a company is only required to pay $250, and all of the other costs of arbitration, including all of the filing fees and the professional fees involved with the arbitrators, as well as the case management fee, which is a 12% tax on literally everything, Patreon will have to pay the rest of it. Now, Patreon had in its terms of service a bar on bringing anything as a class. They said, you cannot bring class actions against us either in court or in arbitration. You waive your right to a class action. Everything has to be brought on an individual basis. So when you think about what's going on from the onset, 100 people filing a JAMS arbitration against Patreon is 100 separate actions. And in each of those actions, just at the start, you have a filing fee. So it's $250 per person. Comes out to 25 grand on one side of the equation. Now, it comes out to like $2,750 or something for the remaining fee that needs to be filed, that Patreon has to bear. So already Patreon is looking at close to 300 grand just in filing fees. Now you've got a 12% tax on that, plus you've got the professional fees. Now the professional fees are the people involved in the arbitration from JAMS. These are arbitrators and they charge lawyer rates. In California, you're looking at several hundred to even pushing towards $1,000 an hour, depending on who it actually is. And that's in each one of the 100 cases. And Patreon pays all of that. So if each one of the 100 arbitrations is 10 hours, even at, say, $400 an hour total, and that's, I mean, that would be getting off easy. That's 4 grand times, that's another $400,000. This is a ton of money that Patreon has written into their own terms of service, okay? So that's why Patreon is desperately trying to get out of this. This is a type of thing that could sink a company like Patreon or put them into a massive amount of debt. What they maybe should have done was just settled and brought Owen back on the platform and not, I mean, that would have been the business smart move, but they haven't done that. So let's see. Several people who are not lawyers claim that Patreon will prevail in its motion against Owen's backers. In fact, the law is pretty clear. Patreon should lose its lawsuit and be sent back to arbitration. I'll report live once the court has issued its ruling. Now, I think Mike is overstating this a tiny bit, but he's confidently stating what likely will happen and probably should happen. I don't know if the law is as clear based on the factual background, and we'll talk about that in a little bit. But after Patreon sued Owens, former backers, the so-called Bears, retained prominent lawyer Mark Randazza. More details to come. Here is the important part. Court, the tentative ruling is to deny the motion for injunctive relief. Patreon is presumably lost unless they're able to persuade the judge at this hearing to reverse himself. That would be, I mean, that's a big task. But the tentative ruling is to deny the motion. Now, the interesting thing about what's going on in this is that and why Mike is saying that the law is pretty clear is because in arbitration, typically the arbitrators get to determine what is an arbitratable cause and what isn't. So the jams would actually be making this determination. Patreon's attempting to short circuit what the procedure is that they asked for. Why I say there's some doubt, we'll see in the we might see it in the filing sections I go through, but the long and short is Patreon attempted to mitigate this in their terms of service changes. So what Patreon would have to do is convince the judge that their changes to the terms of service, which did take place before the arbitration was filed, was valid and binding on the parties. The Owen's side's argument will be that they filed under the rules that were in place at the time of the dispute, which was Owen being removed, and that they had already notified Patreon of their intent to arbitrate, and they had been in negotiations that were required under the terms of use, and Patreon's attempt to rewrite that section of their terms of use to specifically exclude only their claims amounts to an unconscionable sham contract. So we'll see that in a minute. So Mike keeps going. I'm not going to keep reading all of this. I'm not going to do that because you can go check out Mike's stuff, and I don't want to take all of his words. But he talks about the judge hammering Patreon's lawyer and the arguments that Randazza made. You should go check them out. It's pretty interesting stuff. And again, the implications on this are huge. But the ultimate conclusion is we will have to wait a little while for the judge to issue a written ruling to determine what actually is going on. But right now, the tentative ruling is to deny it. So here is the factual background, and I've highlighted most of the important dates to get a good timeline so you understand exactly what's going on. October 9th, the date the defendants were injured, the operable terms permitted a claim on this basis. But they couldn't file suit nor proceed as a class. In fact, they couldn't even proceed directly to arbitration because Patreon's terms said that it cannot be, they have this negotiation sort of provision in there. So on November 12th, counsel for defendants in the arbitration contacted Patreon in an effort to resolve defendants' dispute. The dispute included but was not limited to a claim of intentional interference in contractual relations due to Patreon's wrongful termination of the account of a creator who defendants supported. Defendants in Patreon were unable to resolve the dispute via direct discussions on December 4th, 2019. Defendants repeatedly stated an intention to move forward with arbitration of the dispute if the dispute was not resolved through direct negotiations. And then closely following the discussions of December 4th, the defendants' withdrawal of their settlement on December 16th, Patreon purported to amend its terms of use specifically to preclude from being brought in arbitration claims relating to the termination of another user's account. They sent out an updated terms on December 20th, precluding users from bringing claims against Patreon for suspending or terminating another person's account. The problem with this is you're waiving a fundamental right to bring a claim with legal merit. And this might be an unconscionable act on Patreon's part. Patreon's terms of service is what's called a contract of adhesion, which means you don't really have the opportunity to change the terms of the contract. Now, if you are in a contract where you negotiate as equals and you say, okay, I can change this or propose a different contract language for your agreement with another person or entity, that's a little bit different. You can waive a lot of legal rights there. But when courts see a contract of adhesion where it says, if you want to use our stuff, you're going to have to do this, and you have no opportunity to negotiate other than to just say no, they take that a little bit differently, and things have to be fairer, for lack of a better word, more fair to the party that is signing without the ability to change the terms. All right, so the purported amendment did not clarify any rights. So they said it clarified their rights, but it didn't clarify anything. It specifically removed the right to bring what would otherwise be a lawful legal action. So the idea is tortious interference, okay? Now, let's do a quick primer on what that is. That means that someone improperly interferes with a contract that they know exists. The idea is that Patreon knows that a contract exists between Owen Benjamin and each one of his backers. How do they know this? It's in their terms of service, or their, the description of their own services, where it says that Patreon is just a connection point and that you have any agreement you have with the backer, not with Patreon. Patreon is not obligated to provide the content that Owen promises to his patrons. Owen is. So if Owen says, look, if you do $20 a month, I will, I'll take off my shirt and sing songs from Silence of the Lambs or whatever. If he does that, then his obligation is to do that. And if he doesn't do that, you can't bring an action against Patreon to force Owen's performance. Patreon's just a middleman. They're just a platform to allow you to make this connection according to Patreon. So now, though, Patreon knows that each backer has some sort of contractual agreement with Owen. They give Owen money, Patreon processes that money, and then Patreon provides a simple place for them to connect. Owen and them, if Patreon removes Owen from the platform, it prevents the ability for the patron to pay Owen and for Owen to deliver the content through the platform that they agreed upon. So the exchange of goods and services cannot take place because Patreon interfered. Now, will they prevail on that claim? They might not. That's not really that important in this case because the real issue is the fees. It's the fees that they have to pay up front. So on January 3rd, so they said that the changes went into effect on January 1st. January 3rd, claimant initiated arbitration proceedings against Patreon in accordance with the provisions of the contract at issue. And that is pointing to the contract that existed prior to the changes. The JAMS streamlined rules and the JAMS consumer minimum standards, including by paying the requisite consumer arbitration fees, submitting a demand for arbitration to JAMS, and serving Patreon with that demand. So this is where they are. Then JAMS issued a second letter. They issued a letter on I believe it was March. They issued a letter on right after receiving the arbitration. They issued a letter stating that they were taking it on, that it'll be administered in this particular way. That was February 3rd, my bad. And then they issued a second letter on March 12th stating that JAMS would not issue a blanket stay for numerous separate actions. Basically, Patreon asked JAMS to stop all of it. And JAMS said, no, this is individual, and that's how you wanted it. Specifically, it stated, Patreon's terms of use state that arbitrations may only take place on an individual basis and no grouping of parties is allowed. So they have to do it all individually, which means that they will again have to make a motion in each one of the 100 actions, and then that motion will have to be weighed out individually in each one of those actions. So then Patreon filed the instant suit for declaratory relief on 5 causes. 1, the defendants are subjected to the purported agreement. That's the new agreement. That defendants' arbitration claims are prohibited. Defendants' arbitration claims are not arbitrable. And that arbitration claims have damaged and will continue to damage Patreon. Yes, they will. If this goes on, it will be devastating. And the claims of the non-California defendants are not governed by California Code of Civil Procedure. So they want a preliminary injunction. That's what's going on here. And that is why, again, Patreon is looking to be on the hook for millions of dollars, potentially. And why is that? There's one more thing to cover in this law, and that's why this is going on. Like, what happened? And this actually happened October 13th of 2019, was when Governor Newsom signed new rules into existence for arbitrations, and we're going to take a quick look at those right now as well. So this is Senate Bill 707 in California. It was, again, written into law on October 13th of 2019. And we're not going to read through the whole thing, but we are going to read through this number 2 section here, because I think this is the one that is the most likely outcome. And stick with me, I'll explain this as we go, but in an employment or consumer arbitration, so we're in a consumer arbitration. Consumer is Owen's backer, and the company would be Patreon, in which the drafting party, Patreon, as defined, is required to pay certain fees and costs during the pendency of an arbitration proceeding. So this is, well, we'll read through both, but no, this is during the pendency of an arbitration proceeding because the arbitration proceeding is going on. This bill would provide that if those fees or costs are not paid within 30 days after the due date, the due date, I believe, is 72 hours. It's 72 hours from when JAM sends you the bill. So if they're not paid within 30 days after the due date, the drafting party, again, Patreon, is in material breach of the arbitration agreement, is in default of the arbitration, and waives its right to compel arbitration. If the drafting party materially breaches the arbitration agreement and is in default of the arbitration, this bill would authorize the employee or consumer to unilaterally withdraw the claim and proceed in a court. So the backers could then withdraw arbitration and then proceed in court, or to compel arbitration as specified. Now, if they proceed in court of appropriate jurisdiction, the bill would provide that the statute of limitations is told, so that doesn't really matter. But, well, in this case, it doesn't really matter. The bill would require the court to impose a monetary sanction on the drafting party who materially breaches an arbitration agreement. So that means that the court must impose a fine on Patreon for breaching if the employee or consumer compels arbitration. Or wait, sorry. Impose a monetary sanction on the drafting party who materially breaches an arbitration agreement, and would authorize the court to impose other sanctions as specified if the employee or consumer compels arbitration. So they can still compel them to go to arbitration. The bill would require the arbitrator to impose appropriate sanctions to the drafting party, including monetary sanctions, issue sanctions, evidence sanctions, or termination sanctions. Those sanctions would be are laid out in here. I'm not going to go to the section of it, but are attorney's fees and costs for the backers. So if they don't, here's the skinny, okay? Here's the skinny. If Patreon does not pay up within 30 days on all 100 of the claims, if they don't pay up in 30 days, they're in default. That means that they lose, basically. And it doesn't mean that they lose the arbitration action, because they lose this one, but then the backers can compel another one or go to court. In either case, there's a monetary sanction. There's also a cost of arbitration plus attorney's fees or the backers' sanctions. So if Patreon doesn't pay up, not only will they then have to go back, and they may have to pay up anyway. Well, they will. I mean, at some point they'll have to pay up anyway. They'll also end up having to pay the attorney's fees for the backers. And that gets devastatingly expensive. Again, millions and millions of dollars. This is massive, because if this preliminary injunction fails, look to see all of your terms of service updated across the board. Big tech will be watching this. They absolutely will. Anyone who uses adhesion contracts and has arbitration clauses in it is going to be looking at this, and the rules are going to change dramatically. But it also shows that we as consumers do have tools in our toolbox to go ahead and combat them. And those tools are often given to us by big tech companies. You just have to find the right situation, and you have to have people willing to put something down on the table. In this case, 100 people have been willing to put $250 down on the table each, and then have Patreon name them all in a lawsuit along with the city in which they live. Now, as far as I know, they haven't released their addresses, but in theory, they kind of could. That would have looked even worse for them, for the judge. So thank goodness they didn't. But that's the thing. Dick Masterson's already asking whether or not this can be used against banks. That's an idea that I've had for a while. It's possible. This payment processing deplatforming is one of the most egregious things that's going on right now on the internet as far as censorship. And that's why all of this matters. Owen Benjamin was censored for opinions. Now, Patreon doesn't have to like Owen Benjamin's opinions, but Patreon set themselves up as someone who transfers currency from one person to another. That's basically what they did. They have no obligation to endorse Owen's opinions or anything like that unless they're being pressured by someone else, namely a bank. But we'll see how this turns out. It will be a little while. It could be several weeks to a month before the judge issues an order. But again, the preliminary order in this case is to deny injunction, which means Patreon better go back to that negotiating table or they're going to be ponying up millions of dollars to possibly lose even worse. So I hope you found this interesting and informative. I've been wanting to kind of cover this for a while, but it's a procedurally complicated case. I think Mike, again, oversells it a little bit on saying the California law is pretty straightforward. The law is pretty straightforward. The facts of the case have a couple road bumps that need to be overcome, but it sounds like Randazza did a good job in court today. It sounds like Patreon's lawyers did a pretty poor job in court today, but sometimes judges act that way and they treat the party that they're going to let win more harshly, but it doesn't look like that if there was already a predisposition to deny the injunction. And personally, I think the injunction should be denied. Why don't we hold these companies to account for their choices is beyond me. Of course, Patreon wanted this. They wanted it this way. Now, the reason they wanted it this way is because they never for a moment considered that things would go down this way, because I think at their core, Patreon never considered banning creators at the onset. It doesn't make business sense to ban a creator. Who cares what they say, so long as we get money? Unless they do something horrifically bad. In this case, Owen is just cited with some sort of vague violations of the terms of service, and it kind of looks a lot like censorship. Again, like Owen Benjamin or not, I don't care. I've never seen a minute of his content. I have no idea what he does. Doesn't matter. Patreon wanted this. They wanted this rule set, and now they've got it, and they are desperately trying to get out of it. It's great. We'll be following along. Look for an interview with Mark Randazza, potentially an interview with Day as well about this in the coming weeks, and hopefully we'll get some more info then. If you like this type of stuff, please like, share, subscribe, all of that good stuff. Get the message out there that this is going on. Also get the message out there that just because you don't like someone doesn't mean they don't have a meritorious claim. I know a lot of people don't like Owen Benjamin, Day, but in fact, a month ago, there was a Reddit thread or something talking about how they lost because Patreon filed this motion for an injunction. All of those people appear to be incorrect at this time. So it's pretty interesting. Anyway, thanks for watching. I hope you have a good day. Hope you learned something. Peace. Peace.